Our first argument this morning will be on case numbers 28877 and 28910, Melissa Schmitt versus Shaine Ward. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal, so just let me know if you want to reserve time. The oral arguments, as you know, are being recorded, so stay at the podium, keep your voice up. I don't believe there's any children to be referenced. Okay, so use the initials as opposed to children's names. With that, we've read the briefs and are ready to proceed when you are.
Thank you. May it please this court, counsel. My name is Frank Semino. I am here on behalf of Mr. Ward. This appeal was filed based upon a couple of motions that I had filed back in the common pleas court. I believe that this court obviously has prior experience in this matter and there's a history that's involved. What I'm concerned about is that there is a child support award that I challenged in my motions of June of 2017 and July supplemental in July of 2017.
Semino, were you going to reserve time?
I apologize. Thank you. I'll take 5 minutes.
5 minutes. All right. Sorry to interrupt you.
That's fine. And the concern that I had was that the court, both in Judge Hoffman's order of April the 17th, 2015, and the subsequent orders of Judge Gilletto, that the most recent cases that we had, I believe they were November 1st and December 1st judgment entries of 2017, failed to use the child support computation worksheet. And my appeal is based on the fact that Judge Hoffman completely ignored that in 2015, and again Judge Gilletto in 2017. My concerns are that when you look to the court record, there are 3 child support computation worksheets in the file. One from 2009, one from 2007, one from 2009, and one from 2012. Those were all sole parenting, giving to Ms. Schmitt the child. And there was a child support computation done. The first one, there was income that he was earning at the time. The second one was based basically on unemployment compensation that he was receiving. And the third one by Judge Dezo in 2012 was simply the minimum wage calculation and then using whatever her income was. However, in 2015, no child support computation worksheet was done. There seems to have been an argument, and this court heard this 2 years ago, that there was supposedly an agreement between the parties. There was a hearing on June the 2nd, 2014.
Counsel, if I could ask, you
Yes.
say there seems to have been an argument. Didn't this court, in fact, seems to have been an agreement, or an
Yes.
argument that there was an agreement. Didn't this court, in fact, find that there was an agreement? I guess what I'm saying is, hasn't that ship sailed?
Well, Your Honor, I guess I would say this to you. When we had our hearing in 2017 before Judge Gilletto, he requested that we present to him what was supposed to be an agreement regarding that issue. And all I'm saying to the court is, he, in my opinion, allowed that issue to be addressed again, because I believe that the facts in the case do not support that there was any agreement. I appreciate the fact that Ms. Gradsky raised that in her brief, and the court may have just assumed that, but the facts don't support that.
I'm not sure I understand. We assumed what?
Assumed whatever position that Ms. Gradsky presented in her brief back in 2016. When you look to the case and the arguments or what was done, there was this hearing on the 2nd of June 2014. The very next day, 2 days, Mr. Ward files a shared parenting plan that shows no child support going back between either party. On the court, at the end of that hearing on June the 2nd, 2014, says on page 32 of the transcript of June the 2nd, 2014, I want the parties to provide me with financials. And on June the 11th, Mr. Ward provides his financials to the court. To this day, other than when I requested it back in 2017, Ms. Schmitt has never presented financials to the court in any manner. So then subsequent to that, on June, I believe the 24th, he submits a second shared parenting plan. He filed one on the 4th of June. He filed a second one on 2014. He filed a second one on June the 24th of 2014. And in the interim, he provides his financials. Both of those show that there was no child support to be given. Back and forth between, it was a shared parenting plan. So that goes on, and then I would indicate to the court, again, he was represented at some point by Gary Rosen, and on November the 12th, 2014, another shared parenting plan comes forward, and at that time, again, Mr. Rosen in his proposal says that there should be no child support awarded to either party in that shared parenting plan. Again, in January of 2015, he files another motion indicating these are my financials, and there is no child. I don't have the ability to pay child support. There's a motion for in-camera an interview with the child in March of 2015, and then Judge Hoffman issues his order regarding child support, and he does not mention any word about an agreement between the parties. He simply says that the child support is going to be established at $200 because he doesn't have any income. And that's it. Again, there are no financials from the mother, and the only financials come in from the father.
But back to Judge Callahan's question, why hasn't the ship sailed on that? It could have all been raised in these prior appeals.
Well, I'm indicating to the court that I believe that was resurrected in the hearing that we had on November the 28th, 2017. But again, that issue was raised, and we went through that litany, and we presented to the court the first 6 pages of the hearing of June the 2nd, 2014, and page 32 of that transcript. And I believe it reflects that's what the argument is. And I guess in my opinion, Your Honor, I believe that the court, at no time, even if there was supposedly an agreement, Judge Hoffman's order of April the 17th, 2015, does not reflect, pursuant to the statutes, the basis on which he deviated from a child support computation worksheet that was never done.
And counsel, since that order, have there been appeals? I've lost track of the number of appeals, but there have been.
There was an appeal that I was here before. I challenged the
domestic relations rule, or lack of following the domestic.
They didn't attach a copy of the computation worksheet to the file.
And now you're basically raising the same issue, but aren't you in fact deferring to a footnote that was in our case?
Well, I'm doing more than that, Your Honor. There is no child support computation worksheet.
But there wasn't when you raised this issue on appeal last time.
Correct, but it was aimed solely at that issue regarding the attachment pursuant to the local code.
Isn't it your obligation to raise all of the issues?
Your Honor, I would indicate, I suppose that would be an argument that could be made, all right? But in my opinion, I believe that was then resurrected when we came back in November of 2017.
With Judge Gilletto's
With Judge Gilletto, all right? And I think that issue was requested by him. If you look to his entry of November the 1st, 2017, he asked the parties to bring that information to him, to provide to him that information regarding what had occurred or was there an agreement. And all I can say to the court is, when we had that hearing in November 28, 2017, as far as an agreement, Ms. Gradsky on the record, at page, I believe, 33, and just prior to that, in the transcript of November 28, 2013, says, no, that's not the agreement. We were not going to waive the prior waiver of the prior arrearages on child support prior to June the 1st of 2014. We didn't waive that, but that's what the transcript supposedly says. So is there an agreement? What happened? Judge Gilletto then said to Ms. Gradsky, well, wait a minute, the transcript doesn't say that. Well, we're going to preserve that issue for appeal. This is in November 28, 2017. And he says, well, this is what the record is saying to me, and we're going to now issue an order because there was never any waiver of the arrearages from 2014, prior to June the 1st, 2014. There was never any waiver on the docket. Those arrearages continue to be on the docket and are on the arrearage for the Child Support Enforcement Agency. So that point, it was kind of strange, but Judge Gilletto said, well, wait a minute, you're not agreeing with the record? And Ms. Grassy says, well, I'm going to preserve that right for appeal. And he says, well, listen, go ahead and put an entry on that says those arrearages from June of 1st of 2014 are now waived and are no longer a liability to the defendant. So how could there have been an agreement? How could there have been a meeting of the minds if that was supposedly an agreement back in June the 2nd of 2014, when there's a completely at odds decision or position being taken by Ms. Grassy on November the 28th of 2017? It doesn't make any sense. It does not follow. So there could never have been an agreement to begin with. And I would submit to the court that everything that Mr. Ward did subsequent to the first hearing of June the 22nd, or June the 1st, sorry, June the 2nd of 2014 was contrary to accepting any form of agreement. And my belief is that's why Judge Hoffman did not recognize that in his entry of June the 15th, 2017. He doesn't say there was an agreement. He just says, I'm making this decision. And there was no basis for that decision in that. And Judge Gilletto, in like fashion, when he entered the decision of December the 1st, 2017, again, there is no child support computation worksheet. And I might add that I've been out of the case for a little while, but there was a ruling just in July the 20th of this year. Ms. Grassy was there, and I think Mr. Ward did not appear. But there was again now a change from shared parenting to sole parenting on Ms. Schmitt's behalf, and there is no child computation worksheet in the file. We've checked the record, and there is no child support computation worksheet. And again, it reflects, in my opinion, the fact that they're ignoring it.
Counsel, I'm still a little confused because I understand you're saying your argument is resurrected, but if this court rules on an issue, okay, or has the ability to rule on an issue, but it's not raised, how is that not law of the case? How would the court even have jurisdiction to start looking back as to whether there was a child support computation worksheet?
I guess that wasn't the issue that I raised on that first appeal. All right? I appreciate that. I appreciate your argument to me that, well, Mr. Smino, you should be doing everything you possibly can under the sun.
Well, I'm not trying to give you a hard time. I'm just trying to figure out how a judge can even look at that issue.
Again, I guess I'm relying on what occurred on November the 28th and what the judge's order said of November the 1st, 2017, requesting that information. All right? But more importantly to me,
You're at 3 minutes and 30 seconds.
left total?
Total, so I don't know if you want to reserve the balance or...
No, I will reserve that, Your Honor. But I guess my position is that I think it's jurisdictional. All right? And my position is that the court lacked jurisdiction to render that ruling. Thank you.
May it please the court, my name is Leslie Gransky, and I am here on behalf of Melissa Schmitt in what I believe is the 16th appeal in this matter. I believe there's another one pending, but I think this is number 16 and perhaps 15. I'd like to put one little note in the court's consideration, which is Shaine Ward has an MBA. He has chosen not to work and to just manage some rental property, but he has an MBA. He is abundantly able to work. And I think that's something that should be in this court's framework when it's considering all of the issues at hand. I think it's also clear when one looks at the history of these appeals and his other appeals in this court that he has a history of making an agreement and then backing out of the agreement almost instantly. That's what happened in this case. I acknowledge that Ms. Schmitt did not submit financial information. I don't know how that happened. I do not recall from 4 years ago how that happened. It was not raised on the appeal of the April 17, 2015 order when counsel and Mr. Ward raised the issue of the lack of a child support worksheet. They had abundant opportunity to look at the record and see that there was no worksheet anywhere in the court file, but they didn't. This is being based on counsel's opinion that this is jurisdictional. However, this court doesn't act on my opinion or Mr. Cimino's opinion. It acts on the law. And there is no law that says that the lack of a child support worksheet makes an order void. In fact, the 6th District held in a criminal matter that the lack of a child support worksheet did not make a child support order void so that it couldn't be the basis for a criminal prosecution. If anything, the child support order was voidable. It was subject to direct attack in an appeal. It was given that direct attack, and it was not remanded, it was not corrected. The issues being raised today were not raised. They were available. This court could have considered them at that time. And if Mr. Ward prevails on this appeal, we're going to be here a lot, because every order, if he comes up with a new argument, he's going to be back here. We're back here often enough without opening the door of, I have a new idea on why that's bad. This court should govern based on law of the case, because this court had every opportunity to consider the agreement, which is contained in the transcript of the June 2014 hearing. And I will go to the November transcript in this matter, where I did quite vehemently argue that my client had agreed to dismiss the contempt on the child support arrears, not to dismiss the contempt and the child support arrears. If that issue had been raised in the appeal from the original April 2015 order, I could have gotten that transcript corrected. I could have worked with the judge to say, wait a minute, we were talking about dismissing the contempt, which could have put him in jail, because there had been many contempt issues already at that point, not to give up the arrears. However, it is just not worth it to try to get those child support arrears up to June of 2014, because this man has gone to great lengths to avoid supporting his child while he still goes on ski trips and cruises and takes this child all over the country. It's not worth contesting those previous child support arrears. That's why we didn't appeal, because it's just not worth it. My client has had to pay for 16 appeals. In this case, we received a brief with a single assignment of error and no attachments. The court ordered a corrected brief, and lo and behold, we got 6 assignments of error. My client has really been through the mill on dealing with issues that could have been raised to this court previously, and in part were raised to this court previously, and which were decided, and which should be governed by law of the case. If we take the position that Ms. Schmitt gave up arrears based on MBA income through June 1, 2014, then she really gave up plenty in exchange for a child support order from an MBA of $200 per month. This court has reviewed that, has reviewed his agreement. It has dealt with other cases where Mr. Ward has agreed and then withdrawn his agreement. This court should affirm the judgment of the trial court and continue the $200 order, which is still not being paid, but which at least gives some hope of comfort for this child, so that my client might be able to take a vacation, so that my client might be able to take the boys skiing, so that my client might be able to enjoy being with her son as she works full-time and raises a family. We ask that this court affirm the decision of the trial court. We have filed a motion asking that this court determine that this is a frivolous appeal, and and we would ask for a later hearing on the issue of necessary attorney's fees. Thank you.
Attorney Gransky, when was that motion filed?
I'm sorry. I believe it was filed immediately after the brief. It is, I have made that motion throughout the brief. Because I've had a few appeals, I may be confusing it with the previous one, where I filed a motion immediately after the brief and was granted fees for frivolous appeal. If it hasn't been filed separate from the brief, I will get that done forthwith. Thank you.
3 minutes, 30 seconds.
My basic premise as far as child support is I think the order is void. I believe that the mandatory requirement that a child support computation worksheet be prepared. That language is in every case that I've reviewed. The mandatory requirement that that be done. It was not done. It's not been done. It still isn't being done. I don't understand how that happens, but it has. You can check the court docket. There is not one since 2012. And now it's gone from shared parenting to sole parenting. And again, there is no child support computation worksheet. My only concern, Your Honor, is that under section 3119.24A2, it indicates that there's any deviation from that child support computation worksheet, it's got to be in the record. There is nothing in this record. The only thing is, when you get to paragraph 7, April 17, 2015, it just says, I feel though he doesn't have much income, but I'm going to tell him $200 a month. That's it. That's all it says. It doesn't have a basis for any kind of deviation from anything. I mean, it makes no sense. Judge Giletto, in his orders of December the 1st, indicates again, I'm just going to continue. I asked him to do a child support computation worksheet on the record. He said, no, I'm not going to do it. All right? And then we go ahead and do the subsequent appeals, and I'm telling you, they're not in this most recent orders of July the 20th. There's nothing in the docket regarding that. My concerns also is that when we deal with this, I've also indicated to the court that, there was another issue that we had. There was this issue of $2,428 that was supposedly owed as a part of a property settlement. My client went ahead and paid $6,000 for Dr. Tenner's report. Dr. Tenner had $6,000 of obligation. Mr. Gransky, he paid some of it, he didn't pay all of it. She filed a motion for debt, he paid the balance of it. The court initially said that he would appropriate or apportion that money between the parties. Judge Giletto said that at the November 28, 2017 hearing, but he did not do that. He did not make any apportionment. So I guess to me, I think that was an abuse of discretion on his part also. My basic concern overall is I believe that the decisions by both Judge Hoffman and Judge Giletto regarding child support are void. They have nothing to do on it. I appreciate the idea that the court has looked at this and made a determination that we believe that the order of the child support computation would be somewhere in the file. We stipulate it does not exist. And as a result of that, I believe that the order itself is void. I believe every case that I review indicates that that is mandatory. It is something that needs to be done and needs to be a record. And when it's not, and any deviation needs to be a record so the appellate court can review it. This case is strangely devoid of any kind of detail in that regard. Thank you very much.
Thank you, both counsel, for your presentations today. The court will take this matter under advisement and issue a decision in due course. Clerk of Courts will mail the decision to you on the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website. Thank you again for your arguments.
Thank you.